everybody. Good afternoon. I'm going to just go ahead and get started. This is a case where Mr. Burke has raised the defense of insanity. Mr. Burke has admitted that he committed the acts that led to the deaths of Karen, Koep, and Davido. The evidence shows that Mr. Burke was in the midst of a psychotic episode and was legally insane at the time that he shot Karen and Davido, and the defense urges you to find Mr. Burke not guilty by reason of insanity of both counts of murder in the second degree. Now, as jurors in this case, you must set aside any bias that you have regarding the not guilty by reason of insanity defense. The law recognizes that people can cause great harm but not be criminally responsible. Mental illnesses are complex medical conditions. People do not choose to have mental illnesses. Mental illnesses present in different ways for different people. You cannot look at a person and know what is going on inside their head. The law given to you in this case makes not guilty by reason of insanity a defense available for all four of the charges that the state has brought against Mr. Burke. The not guilty by reason of insanity defense is available even in cases like Mr. Burke's, where the charges are murder in the first degree and murder in the second degree. The not guilty by reason of insanity defense is available in cases like this, where there is great harm and the loss of life. Now, as jurors, you might feel emotional about the loss of Karen and Davido's lives. As jurors, you might feel emotional about the impact the loss of Karen and Davido's lives has had on others. You might, as jurors, feel upset about Mr. Burke's actions that led to this loss of life. You are not deciding whether you like Mr. Burke. You are not deciding whether you think he deserves punishment. You cannot allow emotions to influence how you decide this case. You, as jurors, cannot allow emotions to prevent you from fairly applying the law regarding the defense of not guilty by reason of insanity to the charges in this case. Being a juror is an intellectual exercise and application, not an emotional one. And I'm not just telling you this. This is part of the court's instructions to you. Jury instruction number 1. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. Now, sometimes the law requires you to reach a result that you may not personally be comfortable with. Maybe you personally do not agree with the not guilty by reason of insanity defense. If so, you must set aside any personal disagreement that you have. Again, I am not just telling you this. This is part of the court's instructions. Looking again at a different portion of jury instruction number 1. It is your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proved, and in this way decide the case. Jury instruction number 6. If you find the defendant has established the insanity defense, it will be your duty to return a verdict of not guilty by reason of insanity. Now, just because the defense is asking you to find Mr. Burke not guilty by reason of insanity does not mean that the defense is asking you to make a finding that does not have consequences for Mr. Burke. A finding of not guilty by reason of insanity does not mean that Mr. Burke is just released back into the community. In addition to asking you to find Mr. Burke not guilty by reason of insanity, looking at special verdict forms 1C, 2C, 3C, and 4C, we're asking you to find that Mr. Burke is a substantial danger to other persons unless kept under further control by the court or other persons or institutions. Asking you to find that Mr. Burke presents a substantial likelihood of committing criminal acts jeopardizing public safety or security unless kept under further control by the court or other persons or institutions. And I'm asking you to find that there is not a less restrictive option other than detention in a state hospital that is in the best interests of Mr. Burke and others. Now, you heard from both doctors about how there are people at Western State Hospital who have been committed after a finding of not guilty by reason of insanity. You heard from both doctors about how there are evaluations done after a person has been found not guilty by reason of insanity to assess whether it is safe or appropriate for the person to receive additional privileges within the hospital or to leave the hospital. You heard from Dr. Sutton that sometimes people spend more time in the hospital following a finding of not guilty by reason of insanity than they would have in jail or prison if they had been found guilty. You heard from Dr. Geoffrey Dallery that in the past she worked in a geriatric not guilty by reason of insanity ward. Nobody is disputing, both doctors agree that it is appropriate if you find Mr. Burke not guilty by reason of insanity for him to be kept under further control of the court and for him to be detained in a state mental hospital as opposed to being on a less restrictive alternative. There is a process in place to address risk after a person is found not guilty by reason of insanity. Mr. Burke being found not guilty by reason of insanity does not mean that Mr. Burke returns to the community. Now, the state has charged Mr. Burke with 4 crimes. 2 counts of murder in the first degree and 2 counts of murder in the second degree. There are multiple special verdict forms at play for each count, and of course, you all know that the defense of not guilty by reason of insanity is at issue. Applying the law given to you by the court to the evidence produced at this trial, the defense urges you to find Mr. Burke not guilty of murder in the first degree as charged in counts 1 and 3 because Mr. Burke did not act with premeditation when he shot and killed Karen and Davido. The defense is urging you to answer no to the question regarding whether an aggravating circumstance exists, and the defense urges you to find Mr. Burke not guilty by reason of insanity of counts 2 and 4. Those are the 2 counts of murder in the second degree, and for special verdict forms 2C and 4C to answer yes to questions 1 through 4 and no to question 5. Now, I'm going to spend some time talking to you all about the burdens of proof at issue in this trial. There are multiple burdens of proof. The state, of course, is the plaintiff and has the burden of proving each element of each crime beyond a reasonable doubt. The defendant, Mr. Burke, has no burden of proving that a reasonable doubt exists as to these elements. Now, when Mr. Thunheim was talking to you about the beyond a reasonable doubt burden of proof, he focused in on essentially the last sentence, that if from such consideration, after fully, fairly, and carefully considering all of the evidence or lack of evidence, that you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. There's more to it than having an abiding belief. A reasonable doubt is one for which a reason exists. It can arise from the evidence or the lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. Beyond a reasonable doubt is the highest test of evidence we have The state must prove Mr. Burke's guilt so conclusively that there are no other logical or reasonable explanations based on the evidence. The beyond a reasonable doubt standard is the standard by which the state must prove the element of premeditation found in counts 1 and 3. This is the standard by which the state must prove the aggravating circumstance described in instruction number 26 and number 27. Now, I want to talk to you all briefly about how Mr. Burke did not testify at trial. Mr. Burke exercised his constitutional right to remain silent. Jury instruction number 8 instructs you that the defendant is not required to testify, and that you may not use the fact that the defendant has not testified to infer guilt or to prejudice him in any way. You are not allowed to use the fact that Mr. Burke did not testify to infer that he did not do so because he's guilty. You cannot infer that he did not testify because he's trying to hide something. These are inferences that the law does not allow you to make. If these are beliefs that you would hold outside of this courtroom or outside of the jury deliberation room, these are beliefs that you must set aside for purposes of being jurors on this case. And we talked about this during jury selection. You were all asked during jury selection if you would hold Mr. Burke not testifying against him, and none of you seated here today advised the court or the parties that that would be a problem for you. Now, looking at the charges found in count 1 and count 3, these are the charges of murder in the first degree, and the defense urges you to find Mr. Burke not guilty of the charges of murder in the first degree found in count 1 and count 3 because there is no premeditation. Mr. Burke, he did not deliberate. Mr. Burke, we heard evidence that he acted in the moment in response to an incorrectly perceived threat. Now, looking at the instruction that defines premeditation, premeditation must involve more than a moment and a point of time. The law requires some time, however long or short, in which a design to kill is deliberately formed. The state has not proven beyond a reasonable doubt that Mr. Burke acted with premeditated intent to cause the deaths of Karen and Davido. I argue to you that both the evidence presented at trial and the lack of certain evidence show that Mr. Burke acted without premeditation, and that Mr. Burke is not guilty of the counts of murder in the first degree. Now, you all, of course, have heard evidence that Mr. Burke was armed when he entered into Karen and Davido's home on November 10th, 2023. Mr. Burke having a gun on him when he entered Karen and Davido's house is not evidence of premeditation. There's not evidence that Mr. Burke brought his gun with him to Karen and Davido's house because he had a plan to use it. Or because he had thought about using it at their house. Mr. Burke always had a gun. This is something that you heard about from multiple people. You heard this from Jocelyn Burke, from Logan Goulet, heard from Dr. Sutton, who learned from Mr. Burke's brother that he always carried a weapon. You also heard some references to times that Mr. Burke was asked to leave public places because he was carrying a firearm and making people uncomfortable. There was no plan to take a gun with him. Having a gun with him was Mr. Burke's everyday norm. It would have been unusual for Mr. Burke to not have a gun. Now, Mr. Burke's statements to Dr. Geoffrey Dallery and Dr. Sutton indicate that he had no plan or a thought-out process beyond figuring out whether his daughter Jocelyn was in a body bag inside Karen and Davido's home. You heard Dr. Geoffrey Dallery She did talk about Mr. Burke describing having a plan to clean up the scene of the shootings, and that he described having a plan to move Karen and Davido's bodies. But you also heard from Dr. Geoffrey Dallery that Mr. Burke never expressed to her that he had a plan to shoot Davido and Karen before he entered their home. We heard from Dr. Sutton that Mr. Burke told her, in part, "I didn't know what I was going to do till I did it." I would also argue to you all that the fact that the shootings of Karen and Davido were not premeditated, that Mr. Burke did not think about this beforehand, is shown by what happened after the shootings. Mr. Burke locked himself out of Karen and Davido's house. You heard testimony about how when Karen and Davido's friends and law enforcement came to Karen and Davido's home on the 13th of November, that all of the doors to Karen and Davido's house were locked despite having been drilled. I would argue that it's possible that Mr. Burke got back into the house by going through the garage. There was testimony from several law enforcement officers about the truck door being ajar. Mr. Burke shooting Karen and Davido was unexpected. There's not evidence that Mr. Burke knew Karen would be home when he went to Karen and Davido's residence on November 10th, 2023. There's no evidence presented that Mr. Burke had been to Karen and Davido's home before he went there on November 10th, 2023. And looking specifically about the lack of certain evidence, you heard from Detective Kemke and from Ryan Salmon about all of the data law enforcement had access to in this case. Law enforcement had access to Mr. Burke's laptop. Law enforcement had access to Mr. Burke's phone. We heard from Ryan Salmon that it was a ton of data, approximately 5 terabytes, and a terabyte represents a trillion bytes. And we heard that law enforcement and a forensic expert searched Mr. Burke's computer. I would argue to you they did not find any direct evidence of premeditation. Same for Mr. Burke's cell phone. No direct evidence or circumstantial evidence of premeditation. No evidence of Mr. Burke making threats to Davido. No evidence of Mr. Burke making threats to Karen. I do anticipate, and the state already has to an extent, the state arguing that Mr. Burke searching Lacey Chiropractic back on September 9th, 2023 is somehow evidence of premeditation. There's no context for this search, no evidence related to why Mr. Burke searched for this term, and no evidence of Mr. Burke specifically going to Karen's place of business. During his first closing, Mr. Thunheim talked about how the cell phone tower data places Mr. Burke's phone in the general area of Karen's chiropractic office on November 10th, 2023. That's the general area. It's not by any means conclusive evidence that Mr. Burke went to Karen's chiropractic office on November 10th, 2023. Now, the state has talked about how Mr. Burke turned off his cell phone multiple times on November 10th, 2023, and I anticipate could argue further that that's evidence of Mr. Burke's premeditation or of Mr. Burke having a plan. I anticipate the state arguing that Mr. Burke turned off his cell phone numerous times on November 10th, 2023, because he was going to Karen and Davido's house with the knowledge that he was going to kill them, and that he did not want there to be evidence that his phone was at the residence. That he turned off his cell phone with the goal of evading law enforcement, of evading detection. And you did hear evidence, of course, about Mr. Burke turning off his cell phone multiple times on November 10th, 2023. But then you also heard evidence about Mr. Burke turning his phone back on. including turning his phone back on while at Karen and Davido's house. If Mr. Burke was turning his phone off to avoid creating evidence that he was at Davido and Karen's residence, why would he turn his phone on while he was at Karen and Davido's residence? Now, I'll talk more about this later, but we also know that at this time, Mr. Burke was delusional, that he was experiencing paranoid ideation, and there's evidence that Mr. Burke had concerns about himself maybe being tracked, but certainly other people being tracked. There are other explanations for why Mr. Burke would turn off his phone numerous times on November 10th, 2023. Now, the state might also argue that the evidence of Mr. Burke turning off his phone multiple times is especially important because it was abnormal, that he only had this behavior with his phone on that specific day. But yes, we did hear from Ryan Salmon about how he did not, within the time frame he had access to, see evidence of Mr. Burke turning off his phone multiple times in the same day. But Ryan Salmon also testified that he was not able to say that he had access to the full history for Mr. Burke's phone and Mr. Burke's potential habits when it came to turning his phone on and off. Now, the state has also pointed out that Mr. Burke did web searches and may have asked other people about whether or not cell phones can be tracked when they are off. I would note that the timeline for some of this comes after the shootings. We heard from Mr. Goulet, who described Mr. Burke coming to his shop and asking about whether or not cell phones can track you if they're off. His recollection that this was on November 11th, the day after the shootings, not before. So again, if Mr. Burke is making those inquiries because of a demonstration of a plan, it doesn't make sense that they're coming after the fact. Now, the state also has, of course, focused in on some of what Mr. Burke told Dr. Sutton during her not guilty by reason of insanity evaluation, and has argued that those statements, or some of them, show premeditation. They've pointed to Mr. Burke telling Dr. Sutton that while he was in his car outside of Davido and Karen's home, thinking about whether or not he was going to go inside to figure out if Jocelyn was dead in a body bag, that he said he would call police or kill him. I would argue to you that this is not Mr. Burke saying that he had a plan to go inside and kill Davido once he went inside the residence, but was Mr. Burke speculating about what he might have done if, when he went inside to see if Jocelyn was in a body bag, had in fact found Jocelyn in a body bag, that he would have, in response to finding his daughter, would have called police or killed him. Now, the state both started their opening statements and their closing statements by referencing Mr. Burke stating to Logan Goulet that the only way to get rid of a narcissist is by killing them. The state has placed great emphasis on that alleged statement and is using that statement to argue that Mr. Burke's the killings were premeditated. The defense argument to you all is that Mr. Goulet is not a credible witness. You all, of course, saw him testify, and certainly am not disputing what Mr. Thunheim has told you all, which is that you all are the sole judges of the credibility of the witnesses. But I would argue to you that Mr. Goulet did not appear honest and that Mr. Goulet did not appear accurate. Mr. Goulet, he is the man who worked at the Rapid Repair Shop and who interacted with Mr. Burke when Mr. Burke would come into his business. Mr. Goulet had not interacted with Mr. Burke since November of 2023. I would argue that Mr. Goulet clearly did not like Mr. Burke. Mr. Burke was a paying customer, but it sounds like he was also annoying to Mr. Goulet. He described how Mr. Burke would come in and talk and talk and talk. Mr. Goulet agreed that his memory of his interactions with Mr. Burke was better in 2023 than his memory of his interactions with Mr. Burke were in 2026. You heard from Mr. Goulet that Mr. Burke did not just talk about narcissism in relation to his landlords, that he talked about narcissism related to Vladimir Putin, in relation to Mr. Goulet's girlfriend, in relation to Mr. Goulet's ex. Mr. Goulet stated on the stand in trial for the first time that he thinks Mr. Burke made the comment about the only way to get rid of a narcissist is by killing them in relation to his landlords. But also, that's not what he told law enforcement back in 2023. When he spoke to law enforcement back in 2023, at a point in time where he agrees his memory of his interactions with Mr. Burke was better, he then told them that that statement was in the context of Mr. Burke talking about Vladimir Putin. And law enforcement, they talked to Mr. Goulet twice. They talked to him shortly after Koep and Davido went missing in 2023, and then law enforcement talked to him again in April of 2026. And Mr. Goulet has told law enforcement two different things, and then you all something new, something different on the stand. Because when he spoke to law enforcement in 2026, he said that the only way to get rid of a narcissist is by killing them statement was in the context of Mr. Goulet talking to Mr. Burke about his contentious divorce. There's, I would argue, no credible evidence that Mr. Burke made this statement. The only way to get rid of a narcissist is by killing them in relation to his landlords. Now, Mr. Burke stating in a general sense, the only way to get rid of a narcissist is by killing them, is also not evidence of premeditation. To Mr. Burke, many people are narcissists. Mr. Burke was focused on this topic. He perseverated on it. Davido is not the only person that Mr. Burke thought was a narcissist. We heard from Detective Kemke, who reviewed Mr. Burke's cell phone and laptop, that narcissism was a reoccurring theme among months of data. Search history for narcissism, narcissistic abuse. My recollection is that Detective Kemke's words were that there is a significant digital footprint related to just this general category of narcissism. That there were dozens and dozens of YouTube videos. You all heard from Ryan Salmon, who testified that from October to November of 2023, Mr. Burke's phone used the Firefox browser to search for narcissism-related topics nearly daily. You heard from Dr. Sutton about how during her interviews of Mr. Burke, he described many people in his life as being narcissists. His father, his siblings, people he had worked with. You heard from Dr. Geoffrey Dallery about how she noticed that Mr. Burke seemed to have fell into a YouTube vortex where he was consuming lots of videos regarding narcissism, pop psychology, that sort of thing. You heard that Mr. Burke had a habit of calling people who held different opinions than him narcissists, or people who called him out on things, calling those people narcissists. And so Mr. Burke viewed all kinds of people as narcissists. There's something else going on here that was at play when Mr. Burke went to Koep and Davido's house on November 10th, 2023. Now, I do want to talk to you briefly about the aggravating circumstance that the state has alleged in this case. This is the aggravating circumstance that applies to counts 1 and count 3. The defense is urging you to find Mr. Burke not guilty of counts 1 and 3. And if you find Mr. Burke not guilty of counts 1 and 3, you don't even get to this question. This is one of those questions that you don't get to if your decision is not guilty. Now, I want to talk about, let's say you do find Mr. Burke guilty of murder in the first degree. If so, you must answer no regarding whether an aggravating circumstance exists. Now, the aggravating circumstance at issue is whether there was more than one person murdered and the murders were part of a common scheme or plan or the result of a single act of the person. Again, you should find Mr. Burke not guilty of murder in the first degree and not even get to considering this question. Here, the murders were not the result of a single act of Mr. Burke. Mr. Burke took separate, distinct acts in shooting Karen and Davido. I would compare this to examples of instances where a single act results in the death of multiple people. That would be, for example, a single bomb going off, killing multiple people. Somebody committing the act of driving into a vehicle into a crowd, killing multiple people. This is not what we have here. Now, Mr. Burke also did not shoot Karen and Davido as part of a common scheme or plan. A common scheme or plan, that's something above and beyond premeditation. I would argue to you that all of the reasons that show that the shootings of Karen and Davido were not premeditated are also reasons that you should find that the shootings of Karen and Davido were not part of a common scheme or plan. The fact that Mr. Burke did not have a plan is illustrated by how Mr. Burke did not make it far after the shootings. We heard from Detective Brennan that the Wooded Creek or JBLM property where Karen and Davido's bodies were recovered was just a short distance from the Stedman Road property. We saw a map created by Mr. Nodell. That map showed all of the relevant locations to this case. All of those relevant locations are in a very small geographical area. Mr. Burke's residence on the Stedman Road property, Karen and Davido's residence, the location where the bodies of Karen and Davido were found, the location of the Yaris, where Mr. Burke was ultimately located by law enforcement in the woods. Everything is very close together. The incomplete, the bad cleanup shows that Mr. Burke did not think about shooting Karen and Davido beforehand. This shows that Mr. Burke did not have a plan. I went and opened the door, saw blood. That's what Burt Pratt had to say about when he was in the garage and opened the door and looked inside. The fact that a violent act or acts had occurred within Karen and Davido's house was immediately apparent to anyone as soon as they entered Karen and Davido's home. You all, of course, heard from Stephen Greenwood about how blood was located in multiple areas. The hallway, the living room, there was blood in the Yaris and on the Toyota Sienna. There was no plan, there was no scheme. This is not something Mr. Burke thought about ahead of time. This was unexpected, and this was not murder in the first degree. Now, I'm going to pivot and talk to you all about the defense at issue in this case, which of course is the not guilty by reason of insanity defense. This is the one area of consideration where the defense does have a burden of proof in this case. However, the burden of proof on the defense for establishing the insanity defense is different than the burden of proof on the state to prove each element of each charge against Mr. Burke. The state has the beyond a reasonable doubt burden of proof, the highest burden there is. The defense has a different, significantly lower burden of proof, the lowest burden of proof in a criminal case, and that is the preponderance of the evidence standard. That is defined for you in jury instruction number 6. The burden is on the defendant to establish the defense of insanity by a preponderance of the evidence. Preponderance of the evidence means that you must be persuaded, considering all the evidence in the case, that is more probably true than not true. Now, if something is proven beyond a reasonable doubt, then that means the preponderance of the evidence standard has been satisfied. But the opposite is not true. Less evidence is required to satisfy the preponderance of the evidence standard than the beyond a reasonable doubt standard. You can be less sure with the preponderance of the evidence standard. I'm going to talk to you all about a timeline of events that are relevant to the not guilty by reason of insanity defense. And when I talk to you about this timeline, I'm going to talk to you about the delusional beliefs that Mr. Burke held about Karen and Davido. To Mr. Burke, Davido, and to some extent Karen, were scary bad people. And to be clear, the defense is in no way arguing that that is true. These are delusions that Mr. Burke held on beliefs that were not reality-based. Now, if you think about the timeline in this case, it shows Mr. Burke's deteriorating mental state leading up to the shootings. The timeline shows increasing stressors in Mr. Burke's life leading up to the shootings. And when you think about the timeline, it shows you Mr. Burke, a member of the community, just descending more and more into a delusional paranoid state. The timeline of the summer of 2023 to the fall of 2023 shows why this happened when it happened. Nobody is contesting that Mr. Burke is someone who has mental health diagnoses, and Mr. Burke is somebody who has been affected by those mental health diagnoses since it sounds like, was at least as early as early adolescence. And so what changed? What led to things being different in November of 2023? First, we have the arson of Mr. Burke's shed that occurs a few months prior to the shootings of Karen and Davido in November of 2023. It was very much at the beginning of trial that you heard from Detective Koep, but Detective Koep is the one who testified about this, about how there was an arson at the Stedman property. I believe his words were a few months prior, where Mr. Burke was the victim of an arson, that Mr. Burke had a shed he was turning into a home that was burned down, and that someone named Michael Hieronymus was arrested and charged with a crime related to that event. You heard from Detective Koep that he reviewed emails sent by Mr. Burke to law enforcement after the arson. And these emails indicated that Mr. Burke believed Davido was responsible for the arson. Emails that indicated Mr. Burke believed Davido had made people disappear. Emails that indicated Mr. Burke believed Davido might make the suspect in the arson, Mr. Hieronymus, disappear. The fact that Mr. Burke developed a delusional belief that Davido was responsible for the arson is also shown by the testimony of Mr. Burke's daughter, Jocelyn. You heard from Jocelyn Burke that her dad told her that he believed Davido was responsible for the arson. Now, there's not been evidence presented at trial about Mr. Burke voicing delusional beliefs related to Davido before the arson, but there is ample evidence that after the arson, Mr. Burke develops beliefs that are not reality-based about DeVito. And this is, again, these are not beliefs that are based in reality. Someone else has been charged for this crime. There's no evidence suggesting that DeVito is the one responsible, but regardless, and I would argue because of his mental diseases, Mr. Burke believes that, with no evidence, that Mr. DeVito is the one responsible. We also heard from Dr. Geoffrey Dallery that Mr. Burke expressed to her that he thought Karen may have been involved in the death of his daughter as well, and I'll talk about that a little bit here in a little bit. I apologize. I thought these would be easier to read on the PowerPoint. I'm hoping maybe they are on your screens that you have in front of you. But these are some of the text messages that you all have as an exhibit that you'll have access to while you're deliberating. Text messages from Mr. Burke to his daughter Jocelyn, and text messages that the defense argues support the idea that after the arson, Mr. Burke, his paranoia, his delusions become focused on DeVito. Now, we also know that Mr. Burke's 16 or 17-year-old daughter dies, I think we heard October 15th from one witness of 2023. We heard, I believe, October 17th, 2023 from a different witness of a fentanyl overdose. Parents should not outlive their children. It's hard to imagine many life events more stressful than the death of a child. And it's hard to imagine greater grief than the grief of a parent felt for the loss of their child. Of course, grief in the situation that I've described is normal. But I would argue to you that Mr. Burke's presentation following the death of his daughter was not normal. Mr. Burke, who already has developed one delusion about DeVito, that DeVito is the one responsible for the arson, develops the delusion that DeVito was somehow responsible for the death of his daughter in October. And further, develops the delusion that DeVito has a plot against his surviving daughter, Jocelyn. We heard about, again, I'm going to reference Detective Kemke's testimony, that he found evidence suggesting that Mr. Burke became fixated on his surviving daughter, that he reviewed emails indicating Mr. Burke had a belief that DeVito had a plot against Jocelyn, that he might harm or threaten her, poison her, slip her fentanyl, that Mr. Burke was concerned that Jocelyn would be overdosed, sniped, gassed by DeVito. You heard from Detective Kemke, who reviewed communications Mr. Burke had with the Tumwater School District, where he was submitting a public records request on trying to find out about anyone who had requested info or records regarding his daughter. People in Mr. Burke's life become frustrated by Mr. Burke's continued insistence that his daughter's life was in danger. His insistence that they go check on her, and that they not just hear from her electronically, but they see her face, hear her voice. You heard, again, from Jocelyn Burke, who testified that her dad told her that he thought DeVito was responsible for her sister's death. I believe she explained that her dad told her that DeVito hired someone through Bitcoin to kill my sister, that her dad thought DeVito was targeting her, and that her dad thought DeVito wanted her dead. Again, another example of evidence of the delusional beliefs that Mr. Burke holds on November 10th, 2023 is the video introduced by the state of Mr. Burke alone in his vehicle, driving, videotaping himself, talking to himself. Nobody else is there. What does Mr. Burke say? I consider that a threat of violence. He is basically saying, I want to kill you and your family. We also heard testimony that Mr. Burke reported to Dr. Sutton that around, I don't know that there's a specific date given, but my recollection is that Dr. Sutton testified that Mr. Burke reported to her that the day before or sometime close in time to the day of the shooting that he thought he saw Davido leaving Jocelyn's residence. Again, I'm not saying that that's true, but that is something that Mr. Burke thought. To Mr. Burke, Davido had already killed one of his daughters and was an imminent threat to his other daughter. Now, let's look at what we know about November 10th, 2023, the day of the shootings. Here, again, we have one of Mr. Burke's text messages. This is a text that he sent to Nina Christina Collins. Jocelyn's safety is already on Mr. Burke's mind before he interacts with Davido at the Stedman Road property. November 10th, 2023, 3:33 p.m. Is Jocelyn okay? Now we also, I'm not going to play it again, but we have the video of Mr. Burke and Davido interacting at the Stedman Road property. That is right around 4 o'clock. I would argue to you all that this video likely captures the event that Mr. Burke described to both Dr. Sutton and Dr. Geoffrey Dallery when he told both of them that he interacted with Davido at the Stedman Road property earlier on the day of the shootings, and that he thought that Mr. Davido was trying to stop him from looking in the back of Davido's truck, and that this is what made Mr. Burke think, again, incorrectly, but part of what made Mr. Burke think that there was a body bag in Davido's truck. We have further messages to Nina Christina Collins on November 10th, 2023, 4:23 p.m. I'm dying here with worry. 5:59 p.m. Please, I just want to know if she's okay. And then we have at 6:24 p.m. The possible attempt to call Nina Christina Collins. These messages show what Mr. Burke was thinking about right before he entered Karen and Davido's residence. He's frantic. He's thinking about the safety of his daughter, worried that his daughter is dead. This evidence does not show Mr. Burke being angry at it about a possible eviction. These messages don't show somebody contemplating revenge. These messages do not show Mr. Burke thinking about Davido being a narcissist. These messages show that right before Mr. Burke went into Karen and Davido's residence, that he's worried about his daughter. He's thinking about his daughter's safety. Now, after the shootings, Mr. Burke reported feeling a great sense of relief to Dr. Sutton. Again, because he and his delusional state saw Davido as a threat, an imminent threat to himself and the safety of his family. Mr. Burke reported the same, essentially, to Dr. Geoffrey Dallery, that after the shootings, he went out to the car, that he was singing to himself, that he was driving around aimlessly. Now, looking at jury instruction number 5, this is the instruction that establishes the elements of the insanity defense. Now, one requirement for the insanity defense is that at the time of the charged acts, that as a result of a mental disease or defect, the defendant's mind was affected to such an extent that the defendant was unable to perceive the nature and quality of the acts with which the defendant is charged, or was unable to tell right from wrong with reference to the particular acts with which the defendant is charged. Now, the experts agree that at the time of the shootings, Mr. Burke was suffering from a mental disease or defect. There's a disagreement about the specific mental disease or defect. I would argue to you all that that disagreement is minor. What there's clear agreement on is that Mr. Burke at the time of the shootings was paranoid, that at the time of the shootings, Mr. Burke held delusional beliefs about Davido and Karen, and that Mr. Burke reported experiencing auditory hallucinations around the time of the offenses. There's agreement that Mr. Burke has a long history of reporting feeling targeted in multiple contexts by multiple people, that Mr. Burke has a long history of paranoid ideation, and that Mr. Burke has a tendency to misinterpret details or statements as evidence that someone is threatening him. This is the lens through which Mr. Burke sees the world. You heard testimony from Dr. Geoffrey Dallery that she believes at the time of the offenses, Mr. Burke was suffering from delusional disorder persecutory type. You heard from Dr. Sutton that she believes at the time of the offenses, Mr. Burke was suffering from major depressive disorder mild, paranoid personality disorder, and brief psychotic disorder. You also heard that as part of their process, the experts looked at other evaluations that had been completed on Mr. Burke, and that there were multiple evaluations offering Mr. Burke the diagnosis of paranoid personality disorder going back as far as 2021. You heard from Dr. Geoffrey Dallery. I believe she characterized that the difference between delusional disorder and brief psychotic disorder is kind of psychologists nitpicking things. That I believe she described how when she thinks about brief psychotic episodes, that within a particular time frame you can only have so many of those psychotic episodes because they have to last 1 to 30 days. But if you have so many of them in a certain time frame, that you have to start looking at whether it's something else altogether, which is what brought her to the delusional disorder, and is the context in which she made the statement about how sometimes when you have different diagnoses, it can be professionals nitpicking. You heard from Dr. Sutton about how there are lots of overlap between mental health diagnoses. You heard about how many mental health diagnoses exist on a spectrum, and about how it's not uncommon for a person to receive different diagnoses from different mental health professionals. Now, looking again at jury instruction number 5, it's not enough that a person at the time of the charged acts was affected by a mental disease or defect. That's not enough for the insanity defense to apply. For the insanity defense to apply, the mental disease or defect must affect a person's mind to such an extent that they are unable to perceive the nature and quality of the acts with which they are charged, or were unable to tell right from wrong with reference to the acts with which they are charged. There's agreement between the defense and the state. This is an or, not an and. Only one or the other is required. And here, the experts agree that at the time of the offenses, Mr. Burke was able to appreciate the nature and quality of his acts. Where the experts disagree is on the question of whether Mr. Burke was unable to tell right from wrong at the time of the offenses. Not whether Mr. Burke was able to engage in goal-oriented behavior. That's not the question. Jury instruction number 5 presents a question about a specific point in time, whether the defendant, as the result of a mental disease or defect, was unable to tell right from wrong with reference to the particular acts with which the defendant is charged. So we're talking about the time of the alleged criminal acts. This is what the law makes important for your consideration of the insanity defense. Not whether Mr. Burke had the ability to tell right from wrong before the offenses, not whether Mr. Burke had the ability to tell right from wrong after the offenses, not whether Mr. Burke had the ability to tell right from wrong when cleaning up the site of the shooting later on, not whether Mr. Burke had the ability to tell right from wrong when he was moving and disposing of Karen and Davido's bodies. Here, the particular acts that Mr. Burke is charged with are the acts that caused the deaths of Karen and Davido, the acts of shooting Karen and Davido. The acts that the state in this case is alleging were criminal, we heard testimony that they could have happened very fast. You heard from Mr. Nodell, who was the crime scene reconstructionist who also had a significant background in firearms. He testified specific to the firearm at issue in this case that you just pull the trigger, can keep going until you run out of bullets, that you can have 3 to 4 shots a second, and that the gun is essentially ready and will remain ready. So the criminal acts alleged in this case happened very quickly. And here you have 2 different opinions. You have one expert, the defense expert, who opines that Mr. Burke, because of a mental disease or defect, was unable to tell right from wrong at the time of the shootings. And then you have the state expert, who opines that Mr. Burke, while he, yes, was suffering from a mental disease or defect, did have that ability to tell right from wrong at the time of the shootings. This is a question that only has 2 answers. At the time that Mr. Burke shot Karen and Davido, because of a mental disease or defect, was he unable to tell right from wrong? One expert has to be right. There are numerous reasons why Dr. Sutton's opinion is more likely the correct opinion than Dr. Geoffrey Dallery's opinion. There are numerous reasons why you should find that the defense has met its burden. Now, Dr. Sutton testified that it's her opinion that at the time Mr. Burke shot Karen and Davido, that Mr. Burke, because of a mental disease or defect, was unable to tell right from wrong. Dr. Sutton testified that Mr. Burke's delusional beliefs are part of what led him to Karen and Davido's house. The need to find out if Jocelyn was in a body bag inside, the need to protect himself, protect his family. Dr. Sutton took an approach that looks at the science of what happens in the brain of a person experiencing a psychotic episode and high stress. Dr. Sutton drew a picture while she was testifying to help explain, and described how she believes Mr. Burke's mental health symptoms reached a peak, and that's the plateau at the top of the bottom right of what Dr. Sutton drew, when he entered Karen and Davido's home and interacted with Davido. That this was the high point, the peak of Mr. Burke experiencing psychotic symptoms, the high point of Mr. Burke experiencing fear and distress related to his delusional beliefs, that Mr. Burke was, given his delusions, confronted with what he saw as a threat. This is also where Mr. Burke, the high point of Mr. Burke describing experiencing auditory hallucinations. Dr. Sutton testified that part of your brain shut down when you're in this extreme state of arousal, that survival does not take a lot of brain functioning, and that the parts of the brain associated with higher function are not accessible when a person is at this peak, including in Dr. Sutton's opinion, the part of the brain that would have allowed Mr. Burke to understand whether what he was doing was right or wrong. Dr. Sutton testified that after the shootings, that after checking to see if Jocelyn was in a body bag, finding out that she was not, that Mr. Burke would have slowly started to come down from the peak, that Mr. Burke would have over time regained his ability to tell right from wrong, and that the regaining of the ability to tell right from wrong is not like an on-off switch. And this, the drawing that Dr. Sutton made helps, I think, understand why when during cross-examination, when the state repeatedly asked Dr. Sutton about the different things that Mr. Burke did after the fact, it helps explain why the things that Mr. Burke did after the fact, certainly they were data points that Dr. Sutton considered, but they didn't change her mind. Again, because in her opinion, Mr. Burke in the house, interacting with Davido is at that peak, is at that high point, lacks that ability. The incorrectly perceived threat is gone. Mr. Burke discovers that his daughter is not, in fact, dead in a body bag, and Mr. Burke starts to come down and regain abilities that he did not have when he shot Karen and Davido. Now, Dr. Geoffrey Dallery, of course, testified to the opposite, that in her opinion, at the time of the acts charged, Mr. Burke had the ability to tell right from wrong. One data point that Dr. Geoffrey Dallery appeared to place great emphasis on was what Mr. Burke told her during her interview of him on March 31st, 2026. When Mr. Burke told her that he shot Karen because Karen had a phone and he was afraid she would call the police. Dr. Geoffrey Dallery, in expressing her opinion, testified about how if Mr. Burke was worried about law enforcement or aware that there could be negative consequences, that this shows Mr. Burke had the ability to tell right from wrong. Dr. Geoffrey Dallery's opinion, I would argue, was more simplistic than Dr. Sutton's and did not incorporate science around how the brain is affected during periods of extreme arousal related to people experiencing acute mental health symptoms. Dr. Geoffrey Dallery's opinion was also very much based on Mr. Burke's presentation after the shootings. We heard Dr. Geoffrey Dallery stress the importance of reviewing notes from mental health professionals at the facility where Mr. Burke was at soon after the shootings. But Dr. Geoffrey Dallery also stated that she doesn't know much about those interactions with mental health professionals. She doesn't know how long those mental health professionals interacted with Mr. Burke for, and testified that interactions are usually shorter in the type of setting that Mr. Burke was in. Dr. Geoffrey Dallery also stressed the importance of phone calls made by Mr. Burke soon after the shootings. But the first phone call that she reviewed was from November 18th of 2023, so more than a week after the shootings. And even that call placed on November 18th, 2023 still had some evidence of paranoid and grandiose ideation. Other phone calls that Dr. Geoffrey Dallery reviewed and testified about showed more significant paranoid ideation, showed that Mr. Burke still had concerns about the safety of his daughters and was giving them advice not to go outside, to get a P.O. box, not to go online, to bar their doors at night, block their windows, change their names. We also heard that sometimes there was a discrepancy between how Mr. Burke was described in the mental health records at the facility versus how Dr. Geoffrey Dallery observed Mr. Burke to present in the phone calls. For example, there is testimony that looking at floor notes from February 29th, 2024, that it was indicated that Mr. Burke had become extremely psychotic, but then Dr. Geoffrey Dallery testified that this was not reflected in his phone calls during this time period. And I point that out because phone calls are capturing snippets. They're not comprehensive, and sometimes a person might present in one way for part of the time and then present one way in a small period of time. I would also argue that Dr. Geoffrey Dallery did not address descriptions of Mr. Burke after the shootings that conflicted with her opinion. For example, Dr. Sutton conducted a collateral interview with Sean Burke, Mr. Burke's brother, who stated that Mr. Burke seemed weird and off when he interacted with him on November 14th. Logan Goulet testified that he interacted with Mr. Burke on the 11th, that Mr. Burke was rambling all over the place. And there also was testimony from Mary Jackson, the woman who testified about Mr. Burke showing up on her property with his dog, who testified that it seemed like Mr. Burke was experiencing a mental health crisis. Dr. Geoffrey Dallery also characterized Mr. Burke as functioning well around the time of the shootings, and I would argue to you all that this is not in line with the evidence presented at trial. Specifically, Dr. Geoffrey Dallery described Mr. Burke as maybe not being at his best, maybe not 100%, but being functional. We heard evidence at trial that Mr. Burke is a man who has education. He's someone with a bachelor's of science degree, I believe we heard in engineering, and yet he's living in a garage that is not what I think most people would consider to be habitable. Living in a garage with a wall outside of it that he could have constructed out of fear that people would shoot at him in his home. Testimony that Mr. Burke did not hold a regular job. Maybe there was a solar job project that he was trying to work on but wasn't able to because of how consumed he was by looking out for his daughter Jocelyn's safety. We heard that looking at the days leading up to November 10th, 2023, that Mr. Burke was not eating much, that he was not sleeping much. Dr. Geoffrey Dallery also characterized Mr. Burke as being organized and goal-directed after the shootings. Again, it's the defense position that this does not line up with the evidence presented in this case. Dr. Geoffrey Dallery testified that he had a plan, an idea to clean up evidence, and he followed through with that plan. He had a plan to clean up, and then he followed through with it over several days. Dr. Geoffrey Dallery also testified about how, with a disorganized behavior, you would not be able to complete planned actions. I would argue to you all that there are many examples of Mr. Burke not necessarily being able to follow through with his planned actions, especially when it comes to this plan to clean up after the shootings. We saw evidence of Mr. Burke vacuuming up blood, which of course, not successful. And I would argue that a child would recognize that using a vacuum to clean up blood would not work. And yet that's a method that Mr. Burke tried, digging a hole in a wall to remove bullets so that evidence is not left behind, but then leaving a bullet right there on the carpet. Taking steps to conceal his involvement in the shootings, but keeping the firearm used in the shootings on you. Leaving the shell casings with the car that was involved in moving the bodies. using the debit card of a person who you shot days earlier, keeping the receipts on your person. This is not Mr. Burke being a bad criminal. This is someone who's disorganized and not able to completely follow through on the plan of cleaning up. And again, looking at the curve that Dr. Sutton drew, Mr. Burke is on the other side of the peak, coming down, is at a point where he realizes that he's regained some ability to tell right from wrong and knows that he needs to clean up the crime, from the shooting, and has decided to do so, but is not successfully carrying out that plan. This is someone whose brain is still being affected by a mental disease or defect. Additionally, we heard from Dr. Sutton that a person can have the ability to engage in goal-directed behavior, can be organized, but still can lack the ability to tell right from wrong. You heard from Dr. Geoffrey Dallery about a patient of hers who killed their mother because they thought their mother was an alien. That's goal-directed behavior, but someone who was not able to tell right from wrong.
Members of the jury, welcome back. Please give your attention again to Ms. Norton. Ms. Norton, you may proceed when you're ready.
Hello again, everybody. Before the break, I have been talking about how you all heard from Dr. Sutton that a person can have the ability to engage in goal-directed behavior, can be organized, but still lack the ability to tell right from wrong. I'm now going to pivot to talking about some of the criteria that the jury instructions give you when it comes to factors that you may use when deciding which expert's opinion you give more weight to and find more credible. And so looking at jury instruction number 10, this instruction, it's not exhaustive, right? And so if there's a factor that's not in jury instruction number 10 that you decide is important, you of course can still use that factor. But here, it describes that one factor you may consider, among other things, the education, training, experience, knowledge, and ability of the witnesses. And so looking at that factor of education, training, experience, knowledge, and ability, and comparing that factor as it applies to Dr. Sutton and Dr. Geoffrey Dallery, there's ample reason to give more weight to the opinion of Dr. Sutton, and there's ample reason to find the opinion of Dr. Sutton more credible. And so we have two experts. I'm not contesting that Dr. Geoffrey Dallery is in fact an expert. She is a clinical psychologist, just like Dr. Sutton is a clinical psychologist. They took slightly different paths to get to that end result. Dr. Sutton has her PhD, Dr. Geoffrey Dallery has a PsyD. But they both are licensed clinical psychologists. Now, Dr. Sutton has been a licensed clinical psychologist since 2014. Dr. Geoffrey Dallery has been a licensed clinical psychologist since 2019. Now, we also, though, heard about some additional degrees that Dr. Sutton has. Dr. Sutton, after getting her PhD, received a Master of Science in Clinical Psychopharmacology. And Dr. Sutton also talked about how she has a certificate in neuropsychological assessments from the University of California, Berkeley. Now, another similarity that Dr. Sutton and Dr. Geoffrey Dallery have is that they both have private practices. Right now, they're both full-time in private practice, but for both doctors, before going into private practice full-time. They were employed by the state of Washington, specifically at Western State Hospital. Now, they did have different roles at Western State Hospital. Most recently, Dr. Sutton was the Chief Clinical Officer for the Gage Center of Forensic Excellence at Western State Hospital. Before that, she was a psychology services supervisor at the Center of Forensic Services. And before that, she was a licensed psychologist at the Center of Forensic Services. She, in fact, while she worked at Western State Hospital, at some points in time, was a supervisor of Dr. Geoffrey Dallery. Dr. Geoffrey Dallery, she worked at Western State Hospital as a licensed psychologist. Specifically, you heard testimony that her role at Western State Hospital was as a sex offense risk consultant. Now, you also heard about the experience that both of the experts have completing initial not guilty by reason of insanity evaluations. You heard that Dr. Sutton, including the one that she did of Mr. Burke, that this is the third sole author initial not guilty by reason of insanity evaluation that she's conducted. She also noted it's the first one where she's opined that a person met criteria for not guilty by reason of insanity. Dr. Geoffrey Dallery testified that Mr. Burke's not guilty by reason of insanity assessment is her 7th in private practice. I'd also point out to you all, though, that Dr. Sutton testified how while she was at Western State Hospital earlier on in her career at Western State Hospital, how she was involved in many initial not guilty by reason of insanity evaluations, just not in that capacity as the sole author. She was involved in the capacity where she was reviewing somebody else's work or doing part of an assessment for somebody else, not in that sole capacity. Now, looking again at jury instruction number 10, you may also consider the reasons given for the opinion and the sources of his or her information, as well as considering the factors already given to you for evaluating the testimony of any other witness. Here, you should look closely at the quality of the not guilty by reason of insanity evaluation process that was used by Dr. Sutton, and that was used by Dr. Geoffrey Dallery. Each doctor discussed how they reviewed and considered multiple data points when reaching their opinions. And I would argue to you all that in a case like this, the more data points, the better. And that here, Dr. Sutton pursued and collected more data points. Here, the process used by each expert should lead you to place greater weight or significance on the opinion of Dr. Sutton, and the process used by each expert should lead you to find Dr. Sutton's opinion more credible. Now, Dr. Sutton met with Mr. Burke 3 times for approximately 6 hours. Dr. Geoffrey Dallery met with Mr. Burke once. Dr. Sutton met with Burke closer in time to the shootings. The first time that Dr. Sutton met with Mr. Burke was back on April 28th of 2025. That was an in-person meeting. Yes, there was testimony from Dr. Sutton that during this initial meeting with Mr. Burke, that she was focused on the issue of competency. That is not a reason for you to discount the value of this data point. You heard from Dr. Sutton that there's a lot of overlap when it comes to the process for doing a competency evaluation and doing a not guilty by reason of insanity evaluation, and how we also heard from Dr. Geoffrey Dallery that as part of her process of meeting with a person for a not guilty by reason of insanity evaluation, how she's always looking at how they're doing, how their mental status is, so that she can make sure that they're able to go forward with the rest of the interview. And so just because that first interview was competency focused doesn't mean that it wasn't an important, valuable data point and source of information for Dr. Sutton. Dr. Sutton met with Mr. Burke on 2 further occasions, another time in person on June 16th of 2025, and then over the phone on August 21st of 2025. Again, Dr. Geoffrey Dallery met with Burke the one time for 2 hours, and fairly recently, March 31st, 2026. And so you might think, or you might have observed, maybe there were times where it was easier for Dr. Geoffrey Dallery to recall specifics of her meeting with Mr. Burke than maybe it was for Dr. Sutton. And I would argue to you that one explanation, if that was your perception, is that it was just several months ago that Dr. Geoffrey Dallery did her interview of Mr. Burke, versus for Dr. Sutton, those interviews took place some time ago, and some well over a year ago. Dr. Sutton was able to observe Mr. Burke's presentation over time. Dr. Sutton was able to importantly observe changes to Mr. Burke's presentation after Mr. Burke was prescribed and started taking not 1, but eventually 2 antipsychotics. Dr. Sutton conducted multiple collateral interviews with Mr. Burke's brother, Sean, and Sean's wife for the second component of that collateral interview, and then also did a collateral interview with Mr. Burke's sister, Linda. Dr. Geoffrey Dallery did not conduct collateral interviews. Dr. Sutton also described how, as part of her process in approaching a not guilty by reason of insanity evaluation generally, how she consults with other professionals, how she does a review of relevant research and literature, and how she did both of those things specifically in relation to the not guilty by reason of insanity evaluation that she did of Mr. Burke. I do not recall Dr. Geoffrey Dallery describing the same when it came to her process for conducting a not guilty by reason of insanity evaluation. Now, I want to take some time to talk about reasons why Mr. Burke's statements about what happened back on November 10th, 2023 to the experts may have changed over time. There were differences between how Mr. Burke described the events of that day to Dr. Sutton compared to how he described those events to Dr. Geoffrey Dallery. Dr. Geoffrey Dallery's evaluation, of course, came last in time. Dr. Geoffrey Dallery did not ask Mr. Burke about these differences. Most notable, I would argue, of the differences between what Mr. Burke told each evaluator is that Mr. Burke told Dr. Geoffrey Dallery that he shot Karen because she had a phone and he thought she would call the police, versus Mr. Burke described to Dr. Sutton that during the shootings he was acting in the moment, described being in a dreamlike state, described being fearful for his life and the life of his family. Now, the state, during their cross-examination of Dr. Sutton, did focus in on a portion of a quote of what Mr. Burke told Dr. Sutton, and specifically focused in on, and you saw this quote on Mr. Thunheim's PowerPoint during his closing argument this morning, but the quote of, "If she had run away, I probably wouldn't have shot, but I was afraid of her calling the police. But we heard during during the redirect of Dr. Sutton, that was not the full quote. That the full quote was, if she had run away, I probably wouldn't have shot, but I was afraid of her calling police. I should have known she'd be there. She's just standing there glaring at me, like I was having a dream, being in a dream world. I didn't want him to kill me or my daughter. I didn't know what I was going to do till I did it. I didn't want my daughter to die. I shot twice, but the autopsy says 3, so I don't know. I just stood there thinking what happened, like a dream world. And so that's the full quote. Very different, I would argue, when you look at that complete quote versus when you focus in on the first sentence of that quote. And so what are the explanations, the possible explanations for these differences? Both doctors provided an explanation, a potential explanation for the differences. You all heard from Dr. Sutton that as a person returns to reality-based thinking, they apply more meaning to what they've done. That a person tries to interpret their earlier actions through a more logical lens. That people seek out information and try to make sense of what they've done. Mr. Burke's communications with both experts is Mr. Burke trying to explain what he did and why he did it after the fact. Mr. Burke trying to explain what he did and why he did it when he's not in the same psychotic state that he was in when he did what he did. You heard from Dr. Geoffrey Dallery, who agreed that there's research that suggests that when people try to explain their behavior while in an earlier psychotic state, that people try to rationalize their earlier behavior. That there's a human tendency to try to rationalize our actions. That it can be hard to keep separate what a person thinks now about an event versus what a person felt or thought about an event when it was happening. I would also argue that there are differences because Dr. Sutton spent more time with Mr. Burke, perhaps developed better rapport. Dr. Sutton interacted with Mr. Burke closer in time to the shootings, interacted with Mr. Burke when he either was just starting antipsychotics or had not yet started antipsychotic medications. You heard from Dr. Sutton that when she looked at how Dr. Geoffrey Dallery described Mr. Burke, that Dr. Geoffrey Dallery described Mr. Burke as much more logical and planful, and that Mr. Burke did not appear to present as out of touch to Dr. Geoffrey Dallery than he appeared to Dr. Sutton, and that Mr. Burke presented more flexible when he met with Dr. Geoffrey Dallery than when he met with Dr. Sutton. And again, this makes sense. Even looking at Dr. Sutton's 3 contacts with Mr. Burke, she herself saw improvement over time, saw changes in Mr. Burke's presentation over time. It makes sense that that would continue and that Mr. Burke would present differently and maybe articulate things differently when there's a significant gap in time between his last interview with Dr. Sutton and his sole interview with Dr. Geoffrey Dallery. Now, I anticipate the state and the state's rebuttal argument may argue to you something along the lines of, yes, Mr. Burke was suffering from a mental disease or defect at the time of the offenses, but that he was just how he always was, and that this was Mr. Burke at his baseline. I would argue to you that this is not supported by the evidence. You heard from Jocelyn Burke directly. You heard from Jocelyn Burke that in her opinion, her dad got worse after her sister died, that the paranoia increased. And this is saying a lot, folks, because clearly Jocelyn Burke and others described Mr. Burke as showing significant paranoia, as having delusions before his daughter died in October of 2023. But it got worse after that. After her sister died, Jocelyn noted that her dad started showing up at her house to check on her more, knocking on doors, knocking on windows, leaving boards and a drill at her house. This is something that the experts noted as well. You heard from Dr. Geoffrey Dallery. She agreed that Mr. Burke's paranoid ideation appeared to have worsened after the death of his daughter. That Mr. Burke experiencing trauma, such as the death of his daughter and the arson, could have worsened or fed his paranoid tendencies. Dr. Geoffrey Dallery agreed that increased stress, financial, living situation-related stressors, could have worsened or fed Mr. Burke's paranoid tendencies. And we heard similar testimony from Dr. Seddon. Mr. Burke was not at his baseline when he shot Koep and Davido. Mr. Burke was in the midst of a psychotic episode and unable to tell right from wrong. Now, the state finished their first closing argument this morning by making what I will just characterize as a final headshot argument to you all. An argument that Mr. Burke, the pause that the neighbor heard was a pause before Mr. Burke shot DeVito in the head. That there's not evidence supporting that argument. It's an argument that Mr. Thunheim is making, but it's not supported by the evidence. You all, of course, heard from Dr. Quinn. She was the forensic pathologist. Dr. Quinn did not offer an opinion related to which shot would have come first when it came to the gunshot wounds that she observed on both DeVito and Karen. It appears to the defense that the state is relying on Ms. Yoon's testimony that she heard a bang, 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 pause, bang to make this argument. And I would ask you all to keep in mind that the neighbor is making this statement that she heard what she thinks were gunshots while it was storming, while she was watching murder mysteries, and when she heard what she heard, she didn't think enough of it at the time to even look outside. And so it's based off of that neighbor's testimony that the state has come up with this final headshot argument, and that is testimony that you should interpret with great caution. Now, I am just about done, and I just want to come back to the conclusions that the defense is asking you to make. This is a complicated case. There are numerous charges, numerous special verdicts, lots of forms that you're presented with. Now, applying the law to the evidence produced at this trial, you must find Mr. Burke not guilty of murder in the first degree as charged in counts 1 and 3. If you find Mr. Burke not guilty of murder in the first degree as charged in counts 1 and 3, then you should answer, you shouldn't even get to the aggravating circumstance question. If for some reason you do, you should answer no to that question. And you should find Mr. Burke not guilty by reason of insanity of counts 2 and 4. Now, again, let's say you disagree with the defense and you think the state has proven premeditation. If that's the case, you should still find Mr. Burke not guilty by reason of insanity, but as to the murder in the first degree charges. Now, looking at these special verdict forms, the defense is asking you to answer yes to questions 1 through 4 and no to question 5. Now, I am done with my argument now, and I'm going to, in a moment, sit down. Now, Judge Skinder already explained to you all that because the state has the burden of proof in this case, that Mr. Thunheim gets to stand up and give a second closing argument, a rebuttal closing argument. Now, you also know that the defense, in one respect, does have a burden of proof in this case, and that's the defense burden related to the insanity defense. The defense has met its burden. Now, the defense, just like the state, when it comes to the insanity defense, has that burden of proof. This morning, the state gave you their argument about why they believe they met their burden of proof. I just gave you my argument about why I think the defense has met our burden of proof. The state has, of course, heard my argument, and when I sit down, they get to get up and respond. I don't get to respond to arguments that the state makes during their rebuttal. I've argued to you about why we've met our burden. Mr. Thunheim gets to stand up and tell you why he disagrees, and I don't get a chance to rebut that. That's not an option that I have. The state has the final word. And I implore you to all think carefully about what Mr. Thunheim says to you next, and about what the defense may have said in response to Mr. Thunheim's rebuttal argument, if we were given an opportunity to do so. Thank you very much.
Thank you, Ms. Norton. Mr. Thunheim, will you need a moment to change the technology?
If I could, Your Honor, just to reattach my computer and make sure that things are working.
Sure. And then members of the jury, after that, the attorneys trade spots, and Mr. Thunheim make sure that the technology is working. Then I'm going to ask that you give him your full attention for his rebuttal. I also want to let the jury know that we will end today at 4:30, and so if we're not done with closing arguments, we would just do that first thing tomorrow morning. I just wanted you to be aware of that as well. All right, members of the jury, if you give your full attention to Mr. Thunheim. Mr. Thunheim,
All right, ladies and gentlemen, I have a goal to get the arguments done today, so that as you come back tomorrow morning, you can start fresh with your deliberations. So I may go a little bit quicker than I did the last time, and there might be things that I really want to say that I'm going to skip over because I think it's important actually to get this portion done so that you can get on to your role. So here we go. The first thing is I want to remind you again of that powerful tool that I asked you to keep in mind as you continue to evaluate this case, right? And that's your common sense. Please keep in mind your common sense, because we do have a lot of kind of testimony in this case that's high-level psychology. There's kind of theories batted around, diagnosis given, lots of information about at least what I would consider complex psychological terminology, if you will. But what I want to encourage you to do is to do what I would submit to you, Dr. Geoffroy Delarue, I'm trying to use the French if I can, said to you. I'm going to minimize the number of times I use that name. But her approach, right, in terms of, okay, so there's a mental health issue here. We'll concede that. There is a diagnosis. We don't need to debate about what it is, right? You could call it this, we can call it that. There's overlap, all of those kinds of things. But at the end of the day, yes, there was some diagnosed mental health issues going on here. But also, at the end of the day, there's all these facts that show exactly what Mr. Burke did, and that he knew what he was doing, or that he knew the difference, if you will, between right and wrong. Remember the test, the ability to tell right from wrong. Okay, so let's dig into that a little bit. Let's kind of dig into the facts that actually give us clues about this particular issue. I do want to just take a minute and make a couple of comments about arguments that defense counsel made in relation to premeditation and about common scheme or plan. So let me just take it aside for a minute. Defense did exactly what I pointed out in my argument not to do. They used the word plan. Now, I'm not sure that was like intentional in terms of this idea that there has to be a devised plan, but essentially they were attempting to persuade you that in order to get to premeditation, we've got to prove that Mr. Burke, at the moment he decided to go to the house, had already formed the intent or planned to kill Davido and or Karen. But the evidence really suggests in this case, I submit to you, that the focal point of the defendant's energy, whatever that is, was Davido. So let's kind of focus on that. But as I pointed out, the premeditation test doesn't require that, right? The premeditation only requires that there be some thinking about it beforehand, thought over beforehand. And there is clear evidence based on what he said that he was at least thinking about it, right? I was going to go in and either call the police or kill him, right? So there's contemplation. And that is sufficient to at least get us a start to kind of thinking about premeditation. But premeditation, again, at its root, simply requires that there be some of that contemplation, that there be a decision and an intent that forms, and then an act consistent with that decision, right? So don't let defense make that time longer than it needs to be. The instruction simply says more than a point in time, okay? More than a point in time. So there is some process, however long or short, of deliberation, decision, execution, okay? Now, and I think what's really important about this concept is, and we'll talk a little bit more about this, I think, in a little bit, that it's very clear that Mr. Burke was contemplating, because he was already doing things to avoid possible detection for something that was going to happen in his mind, or at least could happen, right? Like shutting off his phone, like going there at night, walking up, those things that I talked about in my first argument, okay? So if that's the case, right, if he's doing things to already avoid detection in terms of being there, then it is more than reasonable to think, why is he doing that? Because he's contemplating exactly what he told the state's psychologist, exactly what he told her he was doing, and that is he was going to go there and either call the police or kill him. Actually, I think he said that to defendant's psychologist. Now, as for common scheme or plan, I don't want to make this more complex than it is. If these two crimes are related to each other, if there's a nexus between the two crimes, then I would submit to you there's a common scheme or plan, okay? And here, there's basically only two reasons why Karen's killed in this case. One, she's a witness. Or two, she's a co-conspirator in the defendant's mind. Either way, it's common scheme or plan, because they are both murdered at the same time for basically the same motive. whether that motive is to prevent her from being a witness to Davido's murder, or they both, essentially in his mind, needed to be murdered. All right. Now, I went through this in my first argument, the NGRI test, and I want to go back through it again in just a little bit more detail, because in my first argument I was focused more on my burden. And as you've heard now, I get a chance to respond to the defense argument and their burden. Okay? We know that they have the burden of proof on this issue by preponderance of the evidence. So they've got to tip the scale now back. They've got to tip the scale over to that NGRI. More probable than not. Okay? If it's not there, right? If the scale is exactly even in your mind, that's not preponderance. If actually the evidence weighs a little bit more in favor of the state's theory, that's not preponderance. They've got to do that. That is their burden. Okay? So that's what we need to be looking at in terms of, let's talk about that evidence around NGRI. Here's the legal test. For the defendant to be found not guilty by reason of insanity, you must find that as a result of a mental disease or defect. Okay. So both psychologists said yes, there is mental illness going on here. And that's really not in dispute, right? Mr. Burke had been living with essentially a paranoid personality disorder for a very long time. At least since he was 18, because apparently that's when they actually start looking at it for diagnostic purposes. Okay, so probably going that far back, but without dispute for a very long time. In fact, it was his, as defense predicted, I would say, baseline. That was his baseline. He'd been living with this paranoid personality disorder for a very long time. And we're not going to argue that that's suddenly resolved before these murders. Okay? What would be the point? So there is. But that's not enough, right? As we've discussed all the way from jury selection, all the way forward, and actually both experts conceded this. The mental illness in and of itself is not NGRI. It's got to have one of those two other things. One, it needs to be so affect the person to the extent that the defendant was unable to perceive the nature and quality of the acts. As I understood the defense's argument, they've conceded that one. And I think both experts did too. Yes. He clearly understood that when he pointed the gun at Karen and Davido and pulled the trigger, he was inflicting harm. Right? That he was in fact shooting them, and that was a harmful act. Right? He knew exactly what he was doing. And arguably, when you look at it in the context again of premeditated intent to kill, and not only did he understand the nature and quality of the act, but he had formed that intent to actually do that act. It was an intentional act on his part. And it was based on a decision that he made. And essentially both experts agreed that he understood the nature and quality of the act, and he was capable of understanding that. So it's the second one that we focus in on, or was unable to tell right from wrong. Unable to tell right from wrong with reference to the particular acts with which he is charged. Okay? So again, we come to this place where the instruction doesn't talk about him understanding that what he's doing is wrong, right? Or knowing that what he's doing is wrong. It's that he can tell right from wrong. And I submit to you that's the difference between insanity and justification. Right? He could feel justified in doing what he was doing based on whatever was going on in his mind, but still have the capacity to understand and to tell right from wrong. Why do we have this defense in the law? It's a reasonable question. And I think defense talked a little bit about it, that this is a defense that exists because at some point when mental illness reaches that level that is talked about in this test, where somebody actually doesn't understand what they're doing, right? They don't understand the nature and quality of their acts. Or they really don't understand right and wrong. All sense of right and wrong is gone. Then kind of what's the point of holding somebody criminally responsible for that act? Okay? Which is why the defense exists, right? But again, think about in that context of to what extreme that needs to be. And here what we've got is an individual who arguably has taken some very clear-minded steps to commit a crime, right, and then cover it up, essentially, or at least cover up his involvement in it. Is that really at a place where we are going to essentially say the defense is met, the insanity defense is met, and we're not going to hold him criminally responsible for what he's done? Okay? So you can kind of ponder that in terms of the context of this test and why this test exists. But the test is the language here, and that is the difference, the ability to tell right from wrong. So we're going to talk a fair amount about that in the next 45 minutes. It's a preponderance. We've talked about that. And I want to be clear that you don't reach this question, okay? You don't reach the question of NGRI until you've already decided if he did the acts that he's charged with, murder 1 and or murder 2, okay? And then you don't go to the 5 questions unless and until you actually make that decision that he's not guilty by reason of insanity. So there's steps in this, and I just want to make sure that you are kind of looking at those steps as you deliberate. Did he do it or not? If he did it, was he insane? Okay, that's essentially the decision points as you go through. Legally insane, obviously. All right, so let's talk about these evaluations. We've got 2 NGRI evaluations, one done by a defense psychologist, one done by a state psychologist. And in context, I think it is somewhat important to realize that the crimes here were alleged to have been committed on November 10th, 2023. The charging language is actually November 10 to November 13 because that's the last time they're seen alive and the first time that they're discovered, that the crime scene is discovered. So there's a reasonable inference. But all the evidence, as you've heard, suggests that it's Friday night, that they're murdered on Friday night, November 10th. Okay? Defense retains Dr. Sutton in early 2025 to conduct a competency evaluation. That competency evaluation by Dr. Sutton, she comes to the conclusion that he's competent. Okay, that's a different process, different test, different analysis. Okay, there may be overlap, but they are very different questions. Only after that point, then, was there a request for a full NGRI evaluation. So that didn't really start until June of 2025. And by that time, the defendant had 18 months, roughly, to be kind of thinking about what's the version of events. What's the version of events that I want to talk about? So it starts that process in mid-2025, but a report issues in December 3rd of 2025. So at that point, then, the state retains its expert, right, who goes to work in January of 2026, does an interview in March of 2026, issues the report in April of 2026. So I thought there was kind of some insinuation that there was this kind of difference between the two evaluations because of the time that had passed. But the reality is neither of these interviews occurred, close in time to what had happened, right? So when Dr. Sutton talks about in her testimony that the defendant has had time to kind of rationalize the things that have happened and to kind of go through that process and so forth, I'm just going to ask you again, come back to that common sense and kind of think about that timing. Think about the timing that has played out in this case in terms of those reports. But even though the defendant has had that time to kind of rationalize, he says things that gives us clues on this specific issue of NGRI, right? He says, we've talked about this before, so I'm not going to spend a lot of time rehashing it, but he admits that that before going into the home, he said he wanted to investigate this body bag. And by the way, the only evidence of this body bag, or purported body bag, or believed body bag, the only evidence of that comes from the defendant's statements to the experts. He never said that to anybody else, right? In any evidence in this case, there's no report of any witness about him talking about a body bag. There's nothing on a video where he talks about a body bag. Nothing. This is simply something that he told these experts during the interviews. That aside, okay, he said that his goal was to determine if it was JB, his daughter, right, and call police or kill him. Now that's a really interesting statement for two reasons from an evidentiary standpoint. One is call police. Okay? Call police. Why would you call police unless you're thinking about right and wrong? You can tell right from wrong. Apparently he is, according to his version, under this belief that Davido has done something to his daughter that is wrong, therefore I should be entitled to call police. Okay? There's right and wrong, evidence of right and wrong there. Or kill him. So from an evidentiary standpoint, I've always talked about why that's interesting from a premeditation standpoint, right? That he's even thinking about it or contemplating it. But again, there's also this idea of justice, right? I'm going to call police or I'm going to kill him. Coming from this kind of sense of justice. And I'm going to submit to you that if he's got a sense of justice, he's got a sense of right and wrong. He can tell right and wrong. He might not have it, he might not be looking at it the same way that you or I or any other member of the community would look at it. But he can still tell from right from wrong. He can still distinguish the two because he has this sense of justice, right? That he is out to get justice. God told him not to bring the gun, but he did it anyway. Okay? So again, the gun comes to the scene despite this inner voice that he calls God or attributes as God. Despite this inner voice telling him, don't do it, he does it anyway. Okay? So he has choice, but also, he has this sense of right and wrong and justice. I may need this. He decided to walk to the house. He says to Dr. Sutton he shoots Karen because he was afraid she would call the police. Afraid of her calling the police. Again, whenever he used the word police, that should be a kind of a clear marker. Because when you talk about calling police, you're talking about invoking the law and law enforcement, which means inherently right and wrong. Right? He's got a sense of right and wrong. To the state's psychologist, he says a similar statement. So even though these statements are, you know, months apart, probably months apart, he does say the same thing to the state's expert, and then he says that he shot her because he thought she was calling the police. And in this version, he actually said that he believed he saw her with her phone, and that she was actively making a move to call police. Now, maybe that's consistent with her being there, having watched what's happened with Davido, and instantly making some kind of furtive movement in which he turns now and shoots her, right? Because he thinks she's getting ready to call police. Again, the word police should be a big red flag for you in terms of looking at right and wrong. Then he talks about cleaning up the evidence. We clean up the evidence, okay? Well, why do you clean up evidence? To avoid detection. Why do you avoid detection? To avoid responsibility. Why do you avoid responsibility? Because you know that it's wrong, or that some people might think it's wrong, particularly the police. Okay? Then he says to our expert, he disposed of the bodies, and he actually intended to go back and bury them, but he didn't because he was afraid he would get caught. If you have no sense of right and wrong, then why worry about getting caught? Right? Why worry about getting caught? So what he says gives you clues about what his state of mind was all the way through that. Let's talk a little bit more about telling right from wrong. This is what, I already kind of talked about this a little bit, this bullet point, in the sense that if Davido had in fact done something to his daughter, right, and, you know, again, I'm kind of assuming for argument's sake that he actually subjectively had this belief. But again, I think one of the questions you gotta ask yourself as you're deliberating is, has defense really proved that? Has defense really proved it just because the defendant said it? So, keep that question in mind. But if DeVito had actually done that, again, when he says call police or kill him, that's kind of a justification, a sense of justification. I've already talked about why that is a clue in terms of his ability to tell right from wrong. But here's perhaps one of the most important clues in this case. He shut his phone off before he went to the house. Now, here's the interesting thing. The evidence is that he actually would do the opposite in any other situation. The phone would be on if he was talking to somebody, particularly if he anticipated some kind of a confrontation or something. It might even be recording. But yet on this one, he turned the phone off and went to the house. And we can, I think, infer from the questions that he's asking, right, the searches that he's doing about can my phone be tracked and so forth, that the very reason he's turning the phone off is because he doesn't want to be tracked to the house. That happens before the murders. Before. So if he can tell right from wrong before and going into it, and then after, then we get to that place where Dr. Sutton, kind of laid out this theoretical thing about the amygdala hijacking, that's what I'll call it. The amygdala hijacking, where just for a little bit of time, just long enough to shoot and kill two people, he can't tell right from wrong. All the time before that he could, all the time after that he could, but in this very moment he couldn't really do it. And that's where I'm going to ask you to really think about your common sense and your common experience, and whether you think that's actually what happened in this case. Now, I'm not saying it theoretically couldn't have happened, but you got to ask yourself, did the defense prove that it happened? Is there a preponderance of evidence that that's exactly what happened? And I submit to you that there's really zero evidence that that happened. Because the only evidence that we have, or form of evidence, is, again, what the defendant said to the experts. He walks to the house to avoid detection, same thing. If you're avoiding detection, if you're trying to avoid, witnesses seeing you, if you're trying to do this in a place where you're not likely to be seen, then there's an argument to be made that you understand and know that you're doing something wrong. He admitted he realized he had a problem and wanted to try not to be in trouble. This is after the murders, when he's talking to, I believe, the state's psychologist. He makes that statement, right? I realized I had a problem and I wanted to not be in trouble. Be in trouble. Well, that phrase "in trouble" again connotates right and wrong. Okay? He may have felt justified, but yet he admitted basically that others may feel differently. I didn't really feel like what I had done was wrong. Justified. But I didn't think other people would see it the same way. So I felt justified, but I don't know if other people would see it the same way. That's exactly telling right from wrong. That is by definition an analysis of right and wrong. If I see it this way, somebody else may see it that way. I may see it right, they may see it wrong. Right? But that's certainly telling the difference between the two. He didn't go back to bury the bodies because he thought he might get caught. We talked about that. There were cops everywhere watching me. Again, avoiding detection. Avoiding detection. His actions were not about fear, let me suggest, but maybe they were about anger. Maybe he was angry because he thought Davido was involved in the arson. Maybe he was angry because he thought maybe Davido was getting ready to evict him. Maybe he was angry because he thought Davido had some, ill will towards his daughter or whatever, right? Could be. Again, the evidence really doesn't make it clear one way or the other. But the whole point is the burden's on defense to prove to you which of those it was.
Objection, Your Honor, misstatement of the law.
I'm going to overrule the objection, but I'm going to remind the jurors that the instruction that I gave, that the attorneys, if they make any argument that that's supported by the evidence or the law that I gave you, you are to ignore that argument. You may continue.
And I'll reiterate that. If I say anything that doesn't comport with your view of the evidence or your interpretation of the instructions that's been given to you by the court, what I'm telling you is not evidence. You go by the way that you look at it, the evidence and the instructions. Then we come to this email. And it was sent on November 11th to his daughter. And look at the email here, the very title of the email, okay? Because defense would have you believe that he's becoming increasingly paranoid, anxious, stressed out, whatever, about the safety of his daughter, okay? But yet, in the title of the email, he says, "I've been leaving you alone. I've been leaving you alone." So he's been able to manage that, right? I've been leaving you alone. I'm managing that because I can manage my paranoia, if you will. But I might just be doing that for a very long time, okay? So kind of alluding now to the fact that there's something different. Something has changed, okay? And then he goes on with this kind of very apologetic email. An interesting email, again, showing his state of mind. Almost a recognition, if you will, that he's done something that at least others would perceive as wrong. Okay? And then, of course, we come to the cleanup. And I spent a lot of time asking Dr. Sutton about this. Are these pieces of evidence that you might consider in terms of evaluating whether the defendant can tell right from wrong. And part of this was about looking at the organization of his thinking, right? What's really going on here? And Dr. Sutton referred to this as I think her term was a half-witted attempt. And I'm going to challenge that. Let's really think through that. Let's really look at what the efforts were. Now, are they like mastermind sophisticated efforts? Yeah, probably not. But on the other hand, is there organization and intention and thought behind the efforts? So he leaves the scene, but then decides he's going back. So he gathers what he needs to do that. He knows he's got to have tools or something to get back in the house. He knows he's got to have things to clean up, so he's got the bleach and the wipes, right? He's got gloves to wear, and he's got these tools. So I think there's actually reasonable. The defense has thought about how he got back in the house as a reasonable thought, right? He tries to drill the doors on the house, and that doesn't work. Because as we know, when Pratt came by there, the door and the sheriff's deputies verified it, the doors were still locked. The locking mechanism's still working on the doors. But the truck door was ajar, right? So could he have gotten in the truck, got the garage door opener and opened the garage and then come in through the garage? I think that's a reasonable theory based on the physical evidence and what we see. But again, think about what went into that. Okay, I'll try this. Well, that's not working, so I'll try the back door. Well, that's not working. Oh, well, I'll try the truck because maybe there's a garage door opener in there. I'll try that. Bingo! Back in the house. Okay, there's some sophistication to that thought. He's wearing the gloves. He wipes things down. He vacuums. Now, there seems to be this idea that, it's foolish to try to vacuum blood up with this household vacuum that's basically Karen and Davido's vacuum, it looks like. That somehow that's just silly. Well, maybe it is if that's your goal, to vacuum up the blood, right? But maybe he's not so worried about Karen and Davido's blood or DNA. Maybe he's just worried about his own, because that's what connects him. And so maybe if you're going to vacuum up hair or trace evidence, that still works. So you vacuum the floor, you vacuum the blood, but you also vacuum the carpet around the area where he was working. And when you look at the photographs of the house, you can go back and look at those while you're deliberating and kind of look at where the area is that was impacted by the vacuum. And think about, was his goal really to vacuum up the blood, or was it really just to vacuum up other trace? Now, if it's other trace, again, that's relatively sophisticated thinking, I would submit. Picks up the casings and the bullets that he can get to, right? He doesn't find the one under the floor, but quite frankly, it took some pretty big efforts to do that, even by the experts with the patrol, right? Yep, he missed one in the hallway. And frankly, I think that was just the first mistake. Probably, I would submit to you, because it's covered in white and it could look exactly like another chunk of wallboard just laying on the floor, unless you really look at it, okay? But clearly has peeled out the wallboard on the other side to dig a bullet out of the wall there. Again, that's some effort that goes into that. So he gathers that up, collects it, moves the bodies into the Yaris and uses the Yaris, not his own car, because he doesn't want DNA in his own car, so he puts it in Karen's car, drives the bodies out, and disposes of them as he talks about, okay, using the gloves. There's hair all over that car, and that's a really interesting fact in this case. Where did it come from? We don't know. But it was more hair, I would submit to you, and you can look at the pictures again, than, why would he spread Karen's hair or DeVito's hair or whatever, but there's hair all over. Unless what he's trying to do is create the haystack for the needle, right? If his own hair, or he's got his own trace evidence in the car, you throw a bunch of hair in there, now the needle is in the haystack, so to speak. Maybe not the best way to do it, I don't know. But you gotta give him credit for thinking about it, and actually kind of thinking about it in a rather sophisticated way. Abandons the car, washes his clothes, right? 3:30 in the morning, he's in the laundry room washing his clothes. Again, we're getting rid of evidence, cleaning up. And then, instead of staying at the residence where he normally stays, he goes and he sets up a tent across the road, on the other side of the road, in some brush away from the road, so as to not be detected or found at the place where he normally stays. And you heard the deputies talk about that, when it actually took a dog to find him. They actually had to use the canine to get a track to actually find him on the other side of the road, on the other side of the Stedman. All right, so he made a couple mistakes. He left the bullet behind, and he forgot about the glasses case. Okay, it was down out of the way, maybe in a hurry, maybe stressed out, who knows? But he leaves that behind. That was a mistake. But does that mean it's half-witted? No, I think that was just a mistake, and I would submit to you that that was a mistake. Because, interestingly enough, without those bullets and those casings, there's really not much to connect him to that until we start to get into the really sophisticated DNA, where we get the touch DNA off the steering wheel and the gear shift, because those bullets and casings have been matched to his gun. All right. So I'm going to go through these points, and actually I'm going to be done right around 4:30, so I think we're going to be right on time. Okay. These are some additional things that I thought of as as the defense was talking about, that I want to share with you. As I said, paranoia was his baseline. He'd been dealing with it his entire life. And somehow defense wants you to say, well, there was the arson, and his daughter died in October, so a month before, 3 weeks before. That now there was this sudden escalation on November the 10th to something that goes way beyond that, to the point of a brief psychotic episode, which by definition, if you recall, lasts a minimum of a day. Okay, so this whole, you got to again think about that in conjunction with the amygdala hijacking theory. Okay. If you go back and look at that video again, you can do it if you want. As far as I know, you'll have the ability to do that. The video with Davido and the defendant interacting on November the 10th. Remember one of the things he said to one of the psychologists, maybe both, is that he felt like Davido was blocking him from seeing in the truck, right? But go back and look at that video again with that in mind, and think about that. At one point, it appears, again, this is, you can see the video and evaluate it for yourself, but as if he's standing like right by the truck. Because the phone, you can see parts of the truck right on the phone from the video, okay? So really think about whether that really happened. Because again, he didn't say anything or relate in any way to anybody concurrent with these events, this whole thing with this whole theory about the body bag. That only came up during the NGRI evaluations. So here's a person that purportedly has this ongoing paranoia. Okay? He is convinced that Davido has ties to some bigger organization, that he has kind of all this power and capability and so forth, and yet he goes to the house to confront him. He goes to the house to confront it. So somehow he overcomes that fear, or what he says is fear. But that's why I want you to also think about, maybe it's not fear. Maybe it's rage. Right? Anger. Despite his recording other confrontations, this time the phone goes off. Right? There's no recording of this. And remember what he said to Davido when that phone was on and that contact earlier in the day? He said, I'm recording this and I'm just going to be recording all the time now. Right? But yet when he goes to the house, the phone is off. There's no recording. What's going on there? Basically, when you look at this, there is zero evidence of this brief psychotic episode happening at the time of the shooting. Okay? Again, other than a diagnosis based on the self-report of Mr. Burke to the psychologist. So at the end of the day, I want you to answer this question, or ask yourself this question. Did defense meet their burden? Did defense meet their burden to prove that there was a mental illness here that had affected the defendant to the degree that he couldn't tell right from wrong? Okay. And if your answer is no, they didn't meet their burden, there's a theoretical possibility that could have happened. I can see an explanation where maybe it could have happened, but their burden is to prove that prove it to the point where you say, yeah, I think that probably happened. That's probably the way it went, right? More probable than not. If your answer is no, then he doesn't meet the criteria for not guilty by reason of insanity, and he's not entitled to that defense. Defense, spent some time talking about this statement. I'm not going to suggest to you that he was already premeditating this event back when he made this statement to the witness, whose name just jumped out of my head. But the point is that he was sharing a belief. He was sharing something that he was thinking about, right? And when we start to move that forward again, he was clearly foreshadowing what was coming, perhaps without him even knowing it. But he became more and more fixated on this idea of narcissists, who they are, what they do. The fact that Davido, he believed Davido was a narcissist. Now is this a statement that somebody makes that is afraid of a narcissist? Or is it a statement of somebody who genuinely believes that the only way to get rid of a narcissist is to kill them? Okay? Unfortunately, in this case, he became fixated on Davido. And unfortunately, Karen was in the wrong place at the wrong time and became the witness that had to be killed. Don't forget the forest for the trees. What I mean by this, and this is my last message to you, we tend to think about cases and pieces of evidence because that's how our minds work, right? But let's look at this piece and kind of think about what that means, and this piece, right? And kind of think about what that means. And we kind of go through a case and we look at different pieces of evidence. It's how we've even argued the case to you. But at the end of the day, your evaluation, I'm going to ask you just to step back after you've done that for a while and not look at each individual tree, but look at the forest, right? What I'm going to ask you to do when you do that is find the defendant guilty of the crime of premeditated first-degree murder for the killing of Davido and for the killing of Karen. Okay. And then I'm going to ask you to find that he was armed with a firearm, and that in fact those two killings were part of a common scheme or plan. And that in fact he does not meet the criteria, that the defense has not proven sufficiently that he was entitled to the defense of not guilty by reason of insanity. In addition to that, if that's your decision, then by definition, you should also find him guilty of murder in the second degree with the armed questions, and with all of those questions being yes. And that is our request. We submit to you that the evidence here is that the defendant did exactly what he predicted he would do before. And that is that the only way to get rid of a narcissist is to kill. Thank you.